11104, Morales versus Morales.
Good morning, Your Honors. May it please the Court, my name is Ruth Ann Withers, and I represent Marlene Morales, the appellant in this case. The statutory standard for modification of child support orders is whether there is an inconsistency between the current order and the order that will result from application of the child support guidelines. Since 1994, there have been separate and distinct standards for modification of custody and visitation orders as opposed to child support orders. Prior to 1994, all modification actions in the probate and family court were lumped under one standard, that is, whether there had been a material and substantial change in circumstances since entry of the prior judgment.
So is the inconsistency in standards, that's a bad word to use, the difference in the two, the statutory versus the guidelines, when the guidelines don't apply, what happens then?
And that is what has happened. Many of the cases that have come before the appeals court and this court, quite frankly, the guidelines have not applied because the party's income have been too high. So in that case, the guidelines do not apply. They're not presumptive.
So we don't have this same,
That's
none
correct.
of the above.
That's correct.
All right, so here we've got child support set before the 2009 guidelines come into effect, right?
Yes, the parties were divorced in May of 2008, and that's when the original judgment went into effect.
Judgment goes into effect, and now there are new guidelines in 2009. What about this guideline provision that a modification shouldn't take place, or the support order, this is the one presumably consistent with the prior guidelines, shouldn't be modified or should be modified if any of the following circumstances exist. The existing order is at least 3 years old. What about that?
Your Honor, as I mentioned before, the law, the statute that's at issue in this case, Section 28, changed in 1994. The reason being Massachusetts had to conform its statutory language to the new federal laws and guidelines.
No, but these are the 2009 guidelines.
That's
So
correct.
they conform to the guidelines. The guidelines say it's got to be 3 years.
Well, the guidelines are actually changed periodically. About every 4 years, the guidelines go through a revision, and that is under federal law, that they have to be revised every so often. So regardless of which guidelines are in effect, that does not, even the language in Section 3.
So we should avoid, we should pay no attention to this language that says the child support order may be modified if the existing order is at least 3 years old.
Well, wouldn't you say that, in fact, the statute has got to supersede the guidelines anyway, whenever they were adopted?
Well, that is correct. Number one, if there is any inconsistency, so to speak, between the guidelines and the statute is the law. The statute would rule.
So
In terms of the 3-year
a child support order is entered in 2008, new guidelines 2009, everybody rushes in to say, aha, new guidelines, inconsistent, got to change.
No,
Is that how it
Justice.
works?
No, Justice Cordy. What I'm saying is that if you look at the language in Section 3, the modification section, you'll see that a child support order may be modified if one of 4 circumstances happens. Number one, whether it's 3 years old, or whether there's been a change in health insurance or some other change in circumstances.
A material change in circumstances.
Correct.
There's no material change in circumstances here. You're saying that's not the standard.
The old standard was that, but since 1994, for the past 18 years, the standard for modifying child support, regardless of what the guidelines that are in effect at that particular time are, is the objective standard, or whether there is an inconsistency between the current order and the guidelines amount. In terms of the 3-year language, that does not conflict with the statutory language. Every 3 years, the Department of Revenue is obligated to look at the orders that are under its purview and to see whether a modification is warranted. The change in the standard, they moved away, and actually in order to streamline the process, I hear your concern about the floodgates opening, so to speak. In order to streamline the process, that's why the law was changed from a subjective standard of material and substantial change to a more objective one. It helps people gain access to the court system, especially those on both sides of the equation, people who are looking to increase their orders as well as decrease their orders. And especially those...
So I am correct. Once there's a change, that means all bets are off and anyone can come in, even though the order may have only been entered a few months before, under the old guidelines, anyone can come in then to get a change.
As long as there is an inconsistency. If there is no change in the party's income, there would be no inconsistency. In other words, if someone came in and their income is the same, their health insurance situation is the same, there's no inconsistency between the order that they have and the order that would result from application of the guidelines.
Is there any de minimis standard that would apply?
Well, what would happen is a trial court judge could find that there was no inconsistency. For example,
What if it's a small one, but but to sort of undo, I mean, that's what I mean about de minimis.
if someone came in and, for example, there was a $1 change or a 50-cent change or what have you, a de minimis amount, then the judge...
Sure, the judge found it was a, 87 cents an hour change.
But that is not the inquiry in terms of what is the inconsistency. Here we had an initial judgment of $172 per week. If you ran the guidelines based on the uncontested evidence and the party's financial statements, the new child support order should have been $304.23 per week. That's a huge inconsistency between 172 and 304.
But what does that mean? The 170 was entered only shortly before these new guidelines. Was it also simply inconsistent with the guidelines at the time?
No, what I'm saying is that was an initial order. The guidelines are used not only when establishing a new order, but also when establishing a modified order. So the guidelines are a presumptive amount. The judge at that time, the trial court judge, used the guidelines to enter an initial child support order.
172.
Exactly.
But you're saying that since you're not questioning that the 172 was correct when
Not at all.
entered. It's that his job changed, his three different things related to how much money he was making from the Department of Corrections.
Right.
changed.
My client came in a year later and requested, and in fact, if you look at the complaint for modification currently used by the Probate and Family Court, the statutory standard of inconsistency is a checkbox on the form. She came in a year later because Mr. Morales' income had increased from a promotion at his job, and her benefits had decreased since that time. And in fact, at the time of the modification trial in December of 2009, Mr. Morales' income had increased by $266 gross per week, and her income from SSI had decreased by $23 a week.
So you're saying, just to get there, that the 78 cents per hour, well, let me ask you this. Judge, the judge made that judgment based on a pay stub, correct?
She did. It appears that she used one or two pay stubs.
Now, is that an error? Is the probate judge required to use the financial statement rather than the pay stubs?
Well, I think I believe it was an error, Your Honor. I had submitted...
Is the judge required to use the financial statements rather than the pay stubs if there's a discrepancy?
Well, I would say so, because the financial statements are sworn under the pains and penalties of perjury that is your correct financial income at that time. And at that time, Mr. Morales' financial statement, the difference was $266 per week. And in fact, if you look at the pay stub, it did not correspond to the time period he was reporting on his financial statement. I submitted as uncontested exhibits his entire 2008 and 2009, up until that point, wage records from the Department of Corrections, which showed, in fact, that he had an increase, a great increase, because he moved from being a corrections officer to an inner perimeter officer. And in fact, he testified, and it was uncontested, that his income, in fact, had gone up by that amount, and that his financial statements showed that.
Now, that was based largely that he was getting more overtime, it sounds, I think, correct?
Well, that is one of the other, so number one, as I've stated, the trial court judge here used the wrong standard. She used the material and substantial change in circumstances when she should have used the statutory standard.
Okay, but
Number
well,
two,
actually,
in
let
terms-
me interrupt my own question and go back to that. I guess the problem I have with that is, according to your analysis, if a judge says, I've looked at the child guidelines, but I think there is a reason to depart from them, and I think it should be $172 per month, as opposed to what the guidelines would say, which is $250. The judge issues that order because there are reasons to depart from the guidelines. Under your statutory analysis, the day after that judgment issues, she can come back and say, I asked for modification because this is now not consistent with the guidelines. Is that what you're saying?
No, Justice Gantz, it is not. And in fact, if you look at the language included in
So
the...
what must that person then do?
You have the same inquiry about whether the guidelines should or shouldn't be departed from.
Exactly. You have to look at and there's no evidence that in this case the child support guidelines were deviated from the original order. You look at whether that deviation still exists. And if that deviation...
Is that what you mean?
Exactly. Whether it still exists. And the judge does have...
Okay, but isn't that another way of saying that there's no material change in circumstances since the last order was entered?
No, Your Honor. The real inquiry is whether there is an inconsistency. And
Well, there is. There's an inconsistency. That's what, there is. The earlier judge justified it, but there still is an inconsistency.
Well, if there is no if the circumstances of the deviation still exist, then there would not be an inconsistency between the current order and the order that will result from applying the
The
guidelines.
practical matter, is that the first question that gets looked at? In other words, if the original child support order, I'm not saying it's this case because I don't think it was. There was no deviation ever. Don't you have to make findings if there's a deviation?
You absolutely do. You have to list what the actual order would be under the guidelines, the reasons, specific facts and reasons why you're deviating from the guidelines and why it's not in the best interest of the child to have the guidelines amount.
So that was not done when the order for $170 a week was set?
No, the 172 was the presumptive amount under the child support guidelines, and that was the original order that was entered.
And now you're saying the presumptive amount a year later or several months later is much more.
Much more, and that's the inconsistency. That's the crux
That's
of the matter.
because there's new guidelines.
No, it doesn't have anything to do with the guidelines that are changed over time. The difference is that Mr. Morales' income had increased, his position had increased, and her income had decreased. The inconsistency we're looking at has nothing to do with the actual guidelines that are in effect. The inconsistency is between the two orders. So, for example, if Ms. Morales had come in and Mr. Morales had not received a pay raise and her benefits had stayed the same, then the 172 may have been what's in effect, and there'd be no inconsistency between the two orders. At that point, the trial court judge could have said, I don't find there's an inconsistency. The 172 stays in effect. That's what's in the best interest of the child. So that's really what you're looking at, the inconsistency between the order that you have and what it would be when you run the guidelines.
And so the judge dealt with that essentially by saying, I don't count overtime because it's erratic, so I'm not counting that. And you're saying that's error.
Well, there are two
Because the
different
judge
errors.
did explain here, hey, I don't count overtime because that's very erratic and it's not required as part of the job and you don't know whether it's coming or going. And she also said, by the way, she's living with someone now who's paying the living expenses, so I don't really count the fact that she's got some decreases on her side.
There were many errors, and the first error was her use of the material and substantial change in circumstances. All of the other parts of her analysis flowed from the use of a wrong standard. In other words, yes, she found that, for example, she didn't want to use the overtime income. In fact, before any testimony was given and any witnesses took the stand, the trial court judge made a blanket statement that she never considers a payor's overtime income. That was error. She also stated...
I'm sorry, it was error because the guidelines say it is to be included as income?
It's error because she should have at least considered it. A blanket statement saying that she never includes or never considers a payer's overtime income is error.
But what if she then, as she did in her rationale, says, I find it essentially to be erratic?
Then she would have the right to do that, as long as she considers it. But her analysis was based on whether she found it was a material and substantial change from the entry of the first order. So what I'm asking your honors to do is to clarify the law and that the correct standard for modification of child support is whether there's an inconsistency, as it has been since 1994. I'm also looking for my client to receive the appropriate amount of child support of $304.23 per week. And in fact, if you actually use what I say are the court's erroneous numbers, this increase of $35 per week, her child support order should still be $253 a week. That's an inconsistency between 172 and what the guidelines state
I
that the
really
amount
don't
should be.
understand that. So if you say, okay, he got a $35 increase a week in salary, and therefore the guidelines, the new guidelines, require an $85 a week increase.
That's correct.
That's because the new guidelines.
It's not because of the new guidelines. It doesn't.
Well, how could that be the case?
Because the guidelines are revised over time. In other words, every 4 years or so, the guidelines are required to be looked at and revised. So regardless of what guidelines are in effect, you run the guidelines at the time that the modification action is being
And these
tried.
guidelines required more money.
Absolutely. They required,
Even if there had been no increase in his salary, it still would have gone up because of the new guidelines.
it may have, it very well may have, even if you use the court's numbers of the smaller increase in his hourly wage, his income would have gone, his child support obligation would have gone up and should have gone up.
If I could, I'm sorry, one more question. Just want to make sure I understand. Part of what you're saying is that if a judge says these guidelines for various reasons, particular to this case, are not appropriate, and I'm going to deviate from them, and does written findings, that finding is not inconsistent with the guidelines because the findings make it consistent?
What a judge would have to do is whether, if the judge decides that it's unjust or inappropriate for the guidelines and against the best interest of the child for the guidelines to be used for various reasons, then they can decide to deviate. But in all cases, establishing and modifying a child support order, the presumptive amount is what...
Right, I understand that. But once the judge makes those findings, 2 months later after the judgment issues, that person then can't come in and say, these are inconsistent unless you show that there are material changes from the deviations?
No, Your Honor, you cannot. That would not be an appropriate basis to bring a modification action, because nothing...
So you'd have to show that something did happen that's different from what the judge earlier had found.
That there would be an inconsistency. So in what you're saying, the same circumstances, if the income of the parties or the health insurance situation of the parties remain the same from 2 months prior, there would be no inconsistency, and that would not be appropriate to modify the order at that time.
So then in terms of the statute, a judge who makes those findings is essentially saying, based on these findings, it is not inconsistent with the guidelines because there are these special circumstances.
It is not. What you're looking at with the inconsistency is whether it's inconsistent with the old order. Thank you very much.
Thank you.